go to Westlaw.com and I search for Matter of Woods. This was dated August 17th, 1994. So, old case. So, David T. Woods was hired as a respondent to John and Tina Robeson. And while representing them, he took on a personal injury action and assumed the duties of filing a notice of tort and began communicating with the adjusting companies. And routinely, the adjusting companies asked for medical expenses or records or hospital bills to prove their claim. But in return, Mr. Woods sent a written list of medical expenses and made no necessary action to communicate with the companies or any of the things that they were asking of them. So about 2 years later, they found out their case was a result of a loss of claims due to no civil complaint being filed. While representing these same clients, they also asked for his assistance in filing a personal bankruptcy. And Woods had noted to them that the bankruptcy court would not treat their petition as a no-asset case because of the pending personal injury claim, but they wanted to proceed with the bankruptcy case anyways, the claim. In them telling him that, he was sort of confused with the other. He thought they were speaking about the abandonment of the injury claim in the other case. But without communicating or asking them which one they were talking about, he just told them that everything was going to be taken care of. And after that, the Robesons received a notice of discharge hearing and later a show cause hearing for dismissal. I'm guessing he was embarrassed, so he promised the Robesons that he would personally finance and refile their petition. But he didn't know that within the next 6 months, it's prohibited. So he did not communicate to the clients, and unfortunately, the bankruptcy was never filed. Because of these actions, Woods resulted as professional misconduct. If you go to the Tennessee rules and look up diligence, it states that a lawyer shall act with reasonable diligence and promptness in representing a client. It did not seem as if he was very prompt or diligent representing these two clients and letting them know the information or being precise with telling them what's going on. And if you look at the Indiana rules, under 1.3 diligence, it's the same exact definition. A lawyer shall act with reasonable diligence and promptness in representing a client. If you notice the word reasonable in these definitions, if you go to the index of the Tennessee rules, professional rules, the terminology 1.0, the reasonable definition is down here, and it says, when used in relation to conduct by a lawyer, denotes the conduct of a reasonably prudent and competent lawyer. Woods did not really demonstrate being competent, in my opinion. Anyways, that's it.